So Alec's going to be talking about collateral consequences in the criminal justice system, and I had a couple quick stories to help illustrate what he's going to be talking about. I had one resident here. His story is he was living independently in his own apartment, and he was charged with a possession, not heroin, meth possession. He was put into jail for 3 days, released back to his house, and his landlord, he did not disclose to his landlord that he had been charged with this, and the landlord kicked him out. And that's how he came to me. He had no place to go. And that's an example of the things that happen in the exterior of what the sentence was. And there's so much more that goes on with the population we serve than just you go to jail, you get out, and it's over. Another example would be I have another resident. He has a DUI. So in order for him to get his license back, he need to pay out of pocket to go attend a crash course, which is about $1,000. To complete his sentence, he has to do these things, and then he has to buy a vehicle, and then he had to pay the reinstatement fees. Well, that's assumed. And then he had to pay another $2,000 to have a breathalyzer device put into his vehicle so he could start it. And that comes with a monthly fee. And then he has to take part in a multiple weekly urinary test, drug tests, which highly more intensive than people on opiate addictions, ironically. And this is somebody who has a hard time getting around as it is. He's older. So this vehicle was his really only means of independence. Prior to that, when he was with me, he was virtually housebound. Of course, we helped him as much as we could, but I'm just trying to help illustrate all the other things that are going on with our folks. And I'm sure Alec will explain it much better than I can. Alec Ewald is a professor in the Department of Political Science at the University of Vermont, where he teaches classes on American politics, constitutional law, and criminal justice. He has published research on the disenfranchisement and collateral consequences of the criminal justice involvement. He is also a former member of the Burlington Dismas House Council, as well as the current vice president of the Dismas House of Vermont statewide board. Every time I talk to him, I find him extremely captivating to listen to. I've been looking forward to this for a long time. And I'm going to turn it over to Alec.
Jeff, right back at you. Thank you. It's an honor to be here. I want to describe this legal landscape that people with criminal justice backgrounds face in the United States. I wanted to mention right away that this is actually something, and Jeff mentioned my involvement with Dismas. That actually started with our family being dinner cook volunteers, I don't know, 8 or 9 years ago in Burlington. And I never discussed this at the house on purpose. I'm there as their guest in their home. And if anyone who lives there thinks for a moment that I'm there to study them, that would be a terrible consequence in my view. So it's that has some costs. I'm often really curious to know what kind of restrictions they're facing, and I often want to know more about this part of their lives. But it's seemed necessary to me to draw that line. I just wanted to mention that at the outset. This phrase is a mouthful. Collateral consequences. It's actually often taken all the way out to 4 C's. Collateral consequences of criminal convictions. As the term is usually defined, a collateral consequence is a restriction on rights and privileges that accompanies a conviction or lower levels of criminal legal system involvement, but is usually not part of the sentence. And that's an important distinction, and I'll come back to that a couple different times. I want to try to describe the landscape of these rules. They're very complex. They vary a great deal across the United States. They take very different legal forms. They're shot through with discretion and complexity. I'll tell a couple of stories, kind of illustrative things from some different research I've done and things I think are particularly important. And I'm going to try to move pretty fast and do the big landscape and trust the Q&A to give us a chance to get into some more depth on things. I do just want to say right away, Jeff and I talked a few days ago, and those two stories are really important in really different ways. One is that notice a couple of things about the housing consequence that person experienced. First, it came from a charge. That's not a conviction. It's not a felony conviction. It's not a misdemeanor conviction. And that's a really important element of this landscape. It's proper and necessary to describe these things as triggered by a conviction. Conviction is still the most common sort of threshold for incurring a collateral consequence, but significant collateral consequences are brought on by criminal legal system involvement short of a conviction. Not only short of a felony conviction, but short of a misdemeanor conviction. Being charged, I have an open case, that's going to bring down a lot of collateral consequences in employment, in housing, and other places too. Having a search warrant issued for your home can get you kicked out of public housing, just the issuance of a warrant. Having a charge that's later dismissed, sometimes the charge itself will still matter. Having a conviction that's expunged or even pardoned can actually still prevent you from getting a professional license down the line. So there's an important element of defining these things that Jeff's story really illustrates about that. Second thing about the housing story there is that's essentially a private, that's a private landlord who's making that decision. And this is a little bit of the negative sort of side of it, if that makes sense. But part of understanding collateral consequences involves what private landlords can do, what private employers can do. On the employment side, a lot of people are familiar with so-called ban the box rules, which I'll come back to, that in Vermont and other places have really shifted the way employment law works. But a lot of what private individuals do to and don't do for each other because of convictions is really unregulated in this country. And that's a really important problem and sort of part of this landscape too. The second story about the DUI is kind of, I don't know, I really, as I told Jeff, I'm really glad to have that pointed out for two reasons. One that's less important, frankly, as a definitional question, if I get a DUI and my license is suspended and I'm required to go to crash courses, that's not a collateral consequence as most people use the term, because it's specific to my conduct. It's specific to the kind of offense that I committed. So a license suspension, it's triggered by a driving violation. That's not really collateral in that sense because it's closely linked to the conduct and to the offense. And that's really important. I'm an academic. I'm sitting here in my nice office and my nice campus, and I'm really worried about citizenship and voting rights and the social status of people and stigma. And a lot of times people are like, that's nice. I need to drive so I can work. I have some real specific practical problems that involve my physical and mental health and my family. And I get that those rules that you study are important and cause harms in this other way. But these rules that I'm describing, they're not always key to the lived experience of people. And I just wanted to note that too. And it's the second part of why I think that story is important. Let me actually start with a story that gets to one of these collateral consequences that us academics haven't probably paid as much attention to as we should. Some of you know that Supreme Court Justice Clarence Thomas famously went like more than 10 years without asking a single question. And reporters say, sorry for the drama, but that heads snapped up when they heard him at the end of this oral argument in the court. The federal government's lawyer said, if there are no further questions, and she was about to close. And Clarence Thomas said this is a misdemeanor violation. It suspends a constitutional right. Can you give me another area where a misdemeanor violation suspends a constitutional right? This was a case of a guy, this is a case called Voisin. He had a misdemeanor domestic violence conviction in Maine. And under federal law, his firearms rights were suspended because of the misdemeanor domestic violence conviction. federal law and state law defined domestic violence differently. There's details of this, which I can try to, by the way, I'm not a lawyer, but I can try to get into that if you want. But that wasn't what got him in trouble in this way. And it wasn't what Thomas was asking about. This guy shot a bald eagle. You can't make this stuff up. And when he got in trouble for that, the feds found out he had a weapon, which he was not allowed to own because he had a domestic violence conviction. And under federal law, you lose your gun rights if you get a felony conviction or a misdemeanor domestic violence conviction. That's not well understood. And the second part of gun rights that I also want to mention, that's also come up in the Supreme Court in the last 10 years, is that federal law suspends your gun rights, but state law restores your gun rights. This is a matter of formal law. Under a federal statute, if I get a felony conviction or a misdemeanor DV conviction, I lose the right to own a firearm, but state law restores it. Quick story from this. I was doing some research talking to probation officers and judges in New York State about something in New York called a certificate of relief. The certificate of relief is meant to help people get jobs if they have a conviction, or maybe get into public housing if they have a conviction. It's not a pardon. It's not a seal of your record. It's a document from the state that says that there's a measure of rehabilitation in your case, and a judge can give it to you, or the State Department of Corrections can give it to you. When I talk to judges and probation officers in New York City, asking them, why do people seek these certificates and how do you decide whether to award them or not? They were like, they're for employment. What are you, stupid? That's the only reason people should be seeking them, to help people get jobs. And if you're trying to get a job as a nurse's aide in New York, if you have a felony conviction, you're barred. But if you have a certificate, you can use that in your appeal to show rehabilitation, they explained. Then I went and talked to probation officers upstate. And you can guess probably what they told me. Well, I'm sure it's the same in rural Vermont as it is here in upstate. Or, well, it's October, so a lot of our guys want to hunt. People were asking for certificates so they could get their gun rights back, so they could hunt. And I had a hard time when I was first talking with judges and hearing this, because I'm like, I didn't actually know the certificate restored your gun rights. And I wound up asking probation, it was all I heard in county after county in upstate New York. People asked for the certificate to get their gun rights restored. And I would ask, well, does it? And do you offer it to them? Listen to this. And this is going to confuse you, and that's the point. This is what a judge told, this is what a probation officer told me about the certificate and guns. My view is, if our judge issues a certificate of relief, I don't think the DA is going to prosecute somebody for criminal possession, knowing the judge said it was okay. So I asked him, I'm not a lawyer. Does a certificate restore the right to own a gun? And he said, this is the probation officer. His answer to that question was, my prediction about what a judge would do, about what a prosecutor would do based on what a judge meant when a judge awarded this state document, is that it does. Look, what is the law and where is the law? This is a critical feature of these collateral consequences. They're really discretionary, they're really confusing, they're really complicated, and they vary by state, even when they involve things that are fundamental constitutional rights, like the right to own a gun. That's what Clarence Thomas was pressing on. The court may return to this soon. There was a lower court case that dealt with this a couple of years ago, where a dissenting opinion got a great deal of attention. That dissenting judge is now Supreme Court Justice Amy Coney Barrett. So the Supreme Court may come back to this, but it's also a really important illustration of the complexity of these rules. I want to say a note about terminology and then just describe really quickly 7 or 8 different areas where these collateral consequences exist in American law. You've heard me say people with backgrounds, people with a felony conviction, people with a criminal justice background. I'm doing this for 2 reasons. One is person first language. This is, popular in the disability community, in discussion criminal justice reform. It's really important to name people as people first rather than, by something that they did or were convicted of doing. The second reason, though, and there's really interesting research on this that I can come back to, it affects us. If you describe someone as as a violent felon, as opposed to describing them as a person with a violent felony conviction. And then you ask people, how likely is this person to commit another crime? Or would you give an interview to this person if they sought a job? You get different results. Using person-first language actually influences the way we imagine the person who's before us. So the second reason, though, for people with criminal legal system involvement is something that Jeff started us with, is convictions are an important threshold, but you can also incur collateral consequences for stuff that is below the conviction level, for involvement that doesn't rise to a conviction. So courts, I'm going to do this one really fast. Collateral consequences are almost never defined as punishments by judges. This has been tested a number of times. I got a criminal conviction, I paid a fine, I was on probation. Now you're telling me I can't get a student loan because Congress passed a new law about that. That's a second punishment. That punishment didn't exist when I committed the crime and when I pled what I pled to. So it's a second punishment. You can't do that. Or I didn't know that was a certain consequence of my crime. My lawyer should have told me that. My lawyer didn't do her job if she didn't tell me about that. If it's not a punishment, those kinds of rules do not apply. So in almost every case, judges have said, these are regulatory, these are civil. They're meant to protect the public or take care of public resources. If a public landlord, Burlington Housing Authority, kicks me out because I have a drug dealing conviction, they're like, look, we're trying to protect our other tenants. We're not trying to punish you. That has nothing to do with it. That's going to happen elsewhere. We're trying to protect our buildings and protect our tenants. It's not a punishment. So they're almost always defined as civil or as regulatory when they're tested. Collateral damage beyond the law, impact on families, finances. Jeff also mentioned this. You might have heard the term LFOs, for legal financial obligations. These are kind of adjacent to collateral consequences, needing to pay fines and fees before you can get the right to vote restored, for example, critical element of this. Communities are really damaged by these consequences. If significant numbers of people in your community can't vote or can't serve on a jury, right, the families are impacted, but also the kind of social status of that community is affected. But also, really important to mention this, some of our most fundamental social measurements are affected by these restrictions. For example, it's hard to compare unemployment rates in the US and Europe because so many Americans have criminal convictions that make it difficult for them to get a lot of jobs, that you're really not comparing similar populations. So unemployment. The census infamously counts people as living in the prison community. I'm gesturing across the lake towards upstate New York, where there are huge prisons full of thousands of predominantly Black men, many of whom are from the Bronx, but they're counted as living in those upstate New York towns. And so the census is distorted by this. And voter turnout figures are distorted by this because in many states, so many people are barred from voting because of a conviction. So let's talk about collateral consequences. In one category, there are two types of restrictions that are so severe that a lot of people sort of place them in their own category. First is immigration consequences. And again, we can come back to these things. Please post questions. Jen has the skill to navigate those, and I really look forward to talking about this. The court actually ruled back in 2010 that immigration consequences are so severe that they actually do amount to a punishment, and my lawyer does have to tell me about them. So immigration consequences, I'm almost certain to be deported if I take a deal giving me a felony conviction, for example, or even a misdemeanor conviction. My lawyer has to tell me about that, or it's ineffective assistance of counsel. Second is restrictions on people convicted of crimes designated as sexual offenses. These are restrictions that can be truly massive: civil confinement lasting after your sentence is over, reporting and registration requirements. This is a notoriously overbroad category. We can come back to that too if you want. Okay, collateral sanctions at home, housing. Federal law only actually bars a couple of classes of offenders from all federal housing. If you're on the lifetime sex offender registry, or if you're convicted of running a meth lab, that's it. Everything else is up to the discretion of the local housing authority, doing what they see fit to protect the health, safety, and right to peaceful enjoyment of the premises of other residents of the housing authority. We can come back to this, but housing is extremely decentralized. The Burlington Housing Authority, actually genuine and national leader in this. There was a HUD publication a few years ago describing, what New York City, New Orleans, Seattle, and Burlington were doing, trying to help people with backgrounds get into public housing. Benefits. Let me slow down just a tiny bit here. SNAP benefits, better known as food stamps. TANF benefits, better known as welfare, cash benefits. Back in the 90s, the Congress enacted, and law professor Bill Clinton signed into law, a federal law that said every state has to ban you forever from getting these two types of benefits if you get a drug felony, or opt out. A bunch of states opted out and said, no offense, Congress, that's the stupidest thing we've ever heard. We will not be preventing people with convictions from getting cash benefits, or certainly from getting food stamps. But a lot of states have modified those bans. So in a lot of states, you have to undergo supervision, testing, go through some treatment. You can't get cash benefits until you do. You can get food stamps. This is really discretionary, and it's really varied and really complicated. So critical food stamps and cash benefits, those rules vary by state in this country. In Vermont, there is no restriction. In most of New England, there is no restriction. Until quite recently, though, New Jersey had restrictions. Actually, New Jersey still has restrictions on cash benefits, but not food stamps. There's a second restriction with a similar structure. Congress said if you get a drug conviction, you have to have your driver's license suspended for a year, even if you don't even own a car, let alone it's not a driving related offense. Again, most states opted out of that restriction, but there are still a few states where you lose your driver's license, even if your drug conviction has nothing to do with driving. And then parenting. Of course, for biological parents, a conviction can impact your fitness and can be part of all sorts of court proceedings there. But there are also restrictions on volitional parenting, people who want to be foster or adoptive parents, through a really complicated area of federal law. There's almost no research on that, by the way. Collateral sanctions at work, employment. Again, Jeff alluded to this a little bit, sort of kind of impact that you see. In the broadest sense, a critical piece of this landscape that I haven't mentioned yet is the giant, sloshing, messy, almost unregulated world of private background check vendors. So if I get a conviction or an arrest and a charge, a state or locality might sell that record to one of the big private vendors, and that might be out there in the ether that anybody, a potential employer, can future see. Even if it's dropped, dismissed, expunged, I'm acquitted, they might see all that. They might see smoke, they might see noise, and they might turn me away because of that. It's a critical element of employment law. There are some restrictions. Now, this is an area I'd love to come back to on the credit reporting agencies. They're supposed to clean up those records. It's difficult to enforce. Private employers are restricted now in a lot of jurisdictions in terms of what they can ask and when. Ban the box, really attractive term. It's a misnomer. And I want to urge people, train your brain to hear postpone the box, because that's what it is. There's a really serious misinformation problem within the collateral consequences landscape. And this is a good place for me to say what that is. A lot of people are eligible to do things and don't know it. And government officials might not know it either. This one is a different kind of misinformation problem. An employer can still ask me after they've offered me a job. They can still, even in the most strict ban the box jurisdictions, New York City, right? You can ask. You can ask me at the interview, look, we'd like to offer you this position. You could start tomorrow. This is a probationary situation. Is there anything we have to run a background check for this position? You ever been in trouble? We gonna turn anything up? I have to tell them, and they can fire me a week later after they look into this. So ban the box is really postpone the box. And that's an important element of what private employers can and can't do. Occupational licensure. This is a really important element of this. And oh my God, time is just rocketing by. Let me actually interrupt myself here and try to share a document with you. Let's see, I just screwed up my first attempt at sharing the screen. Let me try that again. Actually, how about going to, where did that go? Shoot. How about this one? This is the Vermont LNA, a licensed nurse assistant. You guys can see this, right? Have you ever been convicted of a crime other than a minor traffic violation? DUI is not a minor traffic violation. If yes, attach a detailed written explanation and the official court documents. I don't know what you think that means. I'd love to come back to it, but let me just throw that at you and have you see those words and we can come back to it. There's a few different, kind of impacts of that and ways to read that. How about if I want to be a barber in California? One of the most remarkable documents I've come across in this work. California is one of those states where you absolutely can, yes, you can become a barber or cosmetologist with a conviction. Look at the special form that I have to fill out. Please provide, details of this crime, including complete description of the facts and circumstances, who participated, who the victim was, what losses, attach additional pages as needed. And then, just extraordinary, please explain why you committed this crime. Attach additional pages as needed. I laugh too, because supposedly it's less painful than the other thing. But this is in some ways an invitation. It's in some ways an extraordinary burden. You're invited to imagine what those additional pages might consist of. So occupational licensure varies by state. Can you become a barber? Yes, if this. Can you become a tattoo artist? No, unless this. Can you become a home health aide? I'm going to be blunt. Grandma's asleep. The Percocets on one nightstand and the jewelry's on the other. Somebody with 3 theft convictions, but maybe they're just charges and the charges were dropped. In many states, charges, conduct that doesn't lead to a conviction is still grounds for dismissal. This is one critical area where, in the interest of protecting public safety and a vulnerable population, the state might say, we're not looking at your conviction. We're looking at the underlying conduct, and we will determine that by what the cops said you did, not by what the courts and corrections said you did. Voting rights and jury service. I kind of like that this is towards the end, because it's where I started, and it's what I tend to prioritize or privilege, as we academics like to say. Most people with felony convictions in the United States are eligible to vote. A lot of us have written a lot and yelled a lot until our hair fell out about the small number of states where some people are disenfranchised even after their sentence is over. But there are far more states where it's only during incarceration that I would be disqualified. And of course, I think as people on this meeting know, in Vermont and in Maine, people in prison can and do vote by absentee ballot. We can come back to that. We know a little bit about that, talk more about that. But in a lot of states, if you're on probation, you can vote. In some states, if you're on parole, you can vote. There's a lot of misinformation there. A lot of probation officers don't know it or frankly don't care. Some elections officials don't know about it. The documents that you need to get to provide you're eligible can be really complicated. Florida has been nonstop infamous for the last 20 years in this category, and we can talk about that too. Jury service. This is an extraordinary element of this. And I talked about firearms a little bit earlier. So I actually want to close with jury service as a kind of an invitation to this conversation. Because I want to think about this together. Why would we prevent somebody, as every state does, except for Maine? There's no restriction whatsoever in Maine. A lot of other states have temporary restrictions during your sentence. A lot of states have restrictions that say plus a waiting period. A lot of states have restrictions that say you're eligible, but you can still be challenged for cause. And some states, your eligibility is restored automatically. There's some really fascinating research on this just in the last few years, but there's a lot still that we don't know. Why do we do this? Why do we say you are presumed to be incapable of being a juror? if you have a felony conviction? And what does it say about us? And what is the impact of it on our criminal legal system that we do this? One reason why we do it is there's a presumption that you're biased and that you're biased in a certain direction. It's actually not all that clear that that's the way it would work. I've done a little bit of interview work on this basis. There's a little bit more interview work on this basis. There's a lot of people, and again, I'm real curious, Jeff, and maybe others who've had some conversations and some experience in this area. You talk to a lot of people with backgrounds who will say, I could be fair, actually. Look, what I went through was tough, but believe me, I was in prison with some people who needed to be there, and I think that I could. Then you talk to some people who are kind of really sharp about this and say there's certain kinds of conduct, and I won't use their language, but that I'd say guilty 5 minutes into the first day. I wouldn't even need to hear the evidence. Then there's other people who will say, no, what I went through, I actually couldn't be fair about it. So I think it's good to keep me off that jury. Look at the impact on communities, though. If you're a young Black man in Newark and you get to a jury trial, that's not a fair cross-section of your community because of the percentage of young Black men in Newark that have a felony conviction and are eligible to be on that jury. And finally, how should we think about the fact that a lot of people with felony convictions might not want to be on a jury because it's a pain? There's different kinds of harms. And I talked to somebody who I thought this language was really just right. There are some harms that are individual harms and that are harms for families. But then there are other kinds of harms that are communal and civic and that damage us as a society, even if the person involved doesn't know or maybe knows and doesn't care about a particular restriction. Because it still harms us to be saying, you're out. That group of people, you're not the kind of citizen that has this power. You're not the kind of citizen that we can trust with this power. And that's who we tell ourselves that what's being a citizen means is not you. That harms the rest of us in really important and different ways, even if the individual involved doesn't know or perhaps doesn't care about that particular restriction. So that's some of the landscape of collateral consequences. It's two things at once. It's a fundamental shift in the way someone is a citizen and is not a citizen in this country, but it's also something that's really full of discretion and variation. It's not a sharp line where once you're over a line, you can't do all these things. It's discretionary, it's murky, it's complicated, it's full of variation. And we don't really know a lot about the way that, there's a famous law professor who said, discretion and discrimination travel together. These restrictions can still be damaging and stupid and discriminatory, even if they're kind of more porous than we have said. Some doors open for some people, and we need to know more about how that kind of discretion works out. So thank you so much. I know I took a little bit too long there, and I really look forward to more conversation. I also have to say, we're going to have a certain amount of time here to talk. I hope to answer questions, but please write to me. I have lots of documents on my hard drive that I'm eager to share. I am absolutely not a lawyer, but I'm more than happy to engage with people on this because of its substantive importance. I also work for you, Vermonters. This is your land-grant university. And of course, in the Dismas community, I'm eager to serve in any way that I can. So yeah, what do we have for questions, Jennifer?
Wonderful. Alec, thank you so much for the incredibly informative talk on collateral consequences. So now I invite you to put questions in the chat box, or if you prefer, you can raise your physical hand or raise your virtual hand using Zoom. So Alec can start answering your questions, or if you have a comment and not necessarily a question. Okay. So our first question, Alec, is, can you talk about how licensure process requires people to convince boards of evidence of good character?
Yeah, this actually, this actually came up when Jeff and I were talking last week as well. And I was thinking about this morning. I was watching, I'd watched previously TJ Donovan's remarkable presentation to this group. And this is I can't help giving a little bit of an indirect answer. Well, actually, let me try to give a piece of a direct answer first, then I'll circle back. A lot of these restrictions will do exactly that. They'll say, okay, we're denying you right away. You, because of your conviction, you can't get into public housing. Here's how to appeal. Or you can't be an RN here in New York because of your felony conviction. Here is how to appeal. Or you can't be an unarmed security guard here in New York. Here is how to appeal. You need to submit these documents. And I've seen these letters from the New York State Licensing Authority, part of a project I did about this, trying to look at why these judges say yes and say no to different kinds of people. These boards or the administrative law judges who decide these cases, they're usually under the law, they're looking for evidence of rehabilitation from the individual. And they're often also really sensitive to whether the person has other people who can vouch for them. People who are trusted, people who know them well, from employment setting, from a church setting, from some other civic kind of organization. That tends to carry a lot of weight. Personal statements, accepting responsibility, are the things that you'd expect like this. These good character requirements, though, are really notorious. And a number of states have gotten rid of them in the last year because they're so vague and they're so daunting. The piece of TJ's that I want to come back to, though, is, and it's a really important part of thinking about how these restrictions actually work. And again, this might seem odd, and I can't really explain this as well as I wish I could and as well as I need to. TJ talked about a colleague who, as part of the interview process, would ask people, have you ever been falling down drunk? Have you been punched in the face? Have you punched somebody else in the face? And TJ was talking about, what does it feel like in your body, basically, to confront these things? If you're somebody who the government has said no to your whole life, and they meant it in school, in health, in social service agencies, and you've been through some of these other challenges too. When the state says no to me, I'm gonna be like, well, that's it. They said no, they mean no. But if you're somebody who's been brought up to say, oh no, you can always appeal. You can appeal anything. Write them a letter, honey. I'm sure they'll listen to you. Then you're gonna see the part. You're gonna literally see the part about appealing it. This is part of what we really need to better understand, and some of the real danger and maybe the opportunity in these discretionary denials. No, you can appeal. That's a real opportunity for you. Here's the way that you need to do it. It's an opportunity, though, no question. It's an opportunity for really significant discrimination because it's so subjective. Is this person trustworthy? Who is this person who's written a letter on their behalf? Some of these states do have laws that are a little more descriptive and that say you have to look at things like the passage of time. You have to look at other kinds of evidence of rehabilitation like this. You have to consider these things before you can deny them. And they do try to restrict that kind of wild discretion a little bit. So there's a long answer to a really important question about the discretionary nature of these. Yeah, what else?
Great. So from Barty and Drew, and this was actually a question I had as well, it seems remarkable that collateral consequences are not defined as a punishment. Are there societal examples of these beyond criminal justice?
Of civil restrictions beyond criminal justice? Well, I mean, I'm not sure if I understand the question, so please, post or clarification if I'm missing it. An example that used to be, it doesn't work quite as well, but if the government, actually I'll borrow from Don DeLillo's White Noise, if there's an airborne toxic event and the government tells me to stay inside because I might be in danger if I go outside because there's a giant green cloud floating by my house, that's not a punishment. They're telling me to stay in my house for my own protection. So again, sorry, Jeff, this is a challenging thing for those working in the houses even more than for the rest of us, but a quarantine is not a punishment. Might feel like it, but a quarantine is not a punishment. It's a civil restriction. So I'm not sure if that's what the question is getting at, but there are certainly other things that governments do to us where they say, we're restricting your movement here, or we're saying no to you. Student loans are another one. So the student loan is one of the areas where this did go to a high appeals court. And the students made the argument I said earlier, which is like, this is a second punishment. This is an additional punishment on us. And you can't do that. It's a really fundamental ancient idea about criminal law. And the government said, and the judge agreed, the government's just trying to take care of scarce resources. We're just trying to give these student loan monies to the people who are most likely to use them effectively. We're not trying to punish you for your drug crime. we're just trying to take care of the public's money as effectively as we can. We're not trying to punish you. Now, there's a lot of evidence. People in Congress tend to be lazy and zealous and happily describing how much they hate drug criminals. So that case was pretty ugly, to be honest, because there was plenty of evidence that they actually meant it to deter and to punish people. But the federal appeals court was happy to overlook it. So yeah, there are, and again, I would mention housing, because look, there's plenty of people who live in public housing that are like, yeah, get the drug dealers and gangbangers out and please keep them out. But there's other people who live in public housing that say, look, my son's 40, he's been away for 15 years. All the evidence is, and his own personal evidence, he's aged out of crime. Sorry to use the sociological language there, but he should rejoin me. So that's part of how New York City has been doing this, actually. So I don't know if that answers the question, but yeah, there are other things that government does to us that might feel like restrictions because they are, but they really aren't meant to punish us. They're meant to achieve some other kind of civil or public goal. What else?
Another great question from Barty and Drew. Are there data about the discretionary application of collateral consequences on people of color?
In some areas, but really not as much as we wish we knew. One of the best studied areas here is employment. And there are a lot of really good studies. She died tragically young of cancer. Diva Pager wrote articles with colleagues and then a book called Marked about employment and the difficulty of getting an employment with a record. A lot of these studies will send out, in some cases, they send out actual trained actors of different races and genders to actually go to interviews and pretend they are trying to get jobs. This is all ethical if you've gone through the right procedures, or send out online or by paper back in the day, job applications. You can have recognizably, stereotypically African-American names or Hispanic names. This is a sort of part of this research. And in those areas, you absolutely see that race and a criminal record will really interact in nasty ways that race will exacerbate the impact of a conviction background on someone's chances of getting hired. Otherwise, the evidence that we have is really, it's kind of effects-based rather than intent-based, if you will. So we can just sort of see that, the racially discriminatory policing, put it this way, that there was some litigation about voting rights that eventually was not successful in the federal courts. But it said, look, here's the evidence of racial discrimination in the criminal justice system. Picture a pile that you're familiar with. That discrimination leads to a disproportionate number of people, African American, Black Americans in particular, having criminal convictions, felony convictions here in Washington state. That then leads them to be disenfranchised. The reason they're disenfranchised is because of the racial discrimination in the criminal justice system. That's a violation of the Voting Rights Act. So that was an area where it was excruciating because the evidence was really good, but for complicated legal reasons, the courts turned it away. So in employment, there is some evidence that discretionary decisions by employers involves this nasty interaction of race and criminal legal system background. And in voting rights, again, there's this kind of indirect effects-based. In other areas, we really have much less data about how discretionary interpreters, make a housing decision or make a good character decision. We don't really have that kind of on the ground information about what those authorities do with their decision-making power. It's a really great question, though. Can I say one more thing about the employment landscape, though? Because this actually didn't come up, and this is a great article that Diva Pager was a co-author of. Either the biggest or one of the very biggest employers in the United States is the US Army. And a team of sociologists got the Army's data. You can serve with a conviction. You can serve with a felony conviction. There are moral waivers. Each branch has its own process, its own standards for awarding these moral waivers. Here's the result of the study. Soldiers with felony convictions were promoted slightly faster and were dismissed for misconduct slightly less than similarly situated other enlistees in the Army. They got the Army's own data. They spent years analyzing it. And the country's largest employer found people with convictions make really good workers. In this case, really good soldiers. It's a really important study. I hope it gets more attention. It hasn't really so far as much as you'd hope, but it shows it's a very risk-averse organization, obviously, that's not only employing people, but placing them in an extremely important kind of civically high status position. And that's what they found. That's what the Army's experience has been. Great, what else?
Another great question. Does Dismas advocate with Vermont public housing agencies on behalf of clients or in general for other people convicted or charged?
Sorry, what was the very beginning?
Does Dismas advocate?
Dismas.
Mhm.
I will absolutely defer on that question. Have you guys ever been asked to write a letter like so again, go back to the housing example. Have you guys ever been asked for somebody like who's trying to move out or who was with Dismas years ago? I don't know, maybe Rita, maybe you have some stories from the old days too, or maybe somebody's trying to get an LNA credential or some other professional credential. Have you been asked for one of these letters to sort of talk about somebody's background and kind of vouch for them?
I wonder if Jeff is more current. I could comment a little bit on some part of this, but I think Jeff is much more current.
Yeah, I've written letters of recommendation for jobs, for housing. Nothing to the extent of getting a license, but it's actually fairly common for my group.
Mm-hmm. More like letters to private employers.
Yeah,
Like a reference letter, yeah.
because they don't no longer associate with the people they once knew, so this is their new circle of support, so they stay here.
Yeah. If there's not, I don't know if there's other comments on that. I have another, this just reminded me of the reason I had the another document I had up that I won't show, just tell the story. Marky Mark, the singer, and then the great actor, I think, he asked for a pardon a few years ago. He wanted the pardon, and he committed pretty serious violent offense, and actually plural. And he writes about this in his letter. And just Jeff mentioning they no longer associate reminded me of this. In a lot of states, you can't associate with known felons if you've got a conviction. It's like a standard probation condition sometimes, or parole condition. And a lot of reentry organizations have worried about this because a lot of reentry organizations employ people with backgrounds themselves. And they don't expect to get in trouble with probation and parole because they're usually working with probation and parole. But by the letter of the law, if I've got a felony conviction and I'm going into a reentry organization and getting some help from them, I'm associating with known felons and I might get in trouble. Mark Wahlberg said, I'm here in California working with at-risk youth. I'm working with the LA, county sheriff's organization with like probation. And I'd like to be able to take on an official role. He lays this out pretty extensively, the kind of work he's doing with probation and parole. And he says, I might want to actually have an official position with the organization that would help me do some things that I currently can't do. And volunteering with at-risk youth, I'm telling my own story about how much trouble I was in and what a screw up I was and how important second chances are. I can't do it because under California law, I can't work in any public safety position. I can't associate with these youth at risk because of my felony conviction. I also might not be able to he wanted to open his restaurants, his burger, the Wahlburger, right? The farcical, right? But I can't get a concessionaire's license with my felony conviction. So this is the level of these tentacles that extend out into so many different elements of American society. The ability to open a restaurant or work with at-risk youth. Whenever I talk with people, I always like, what am I miss? And I was talking with somebody here in Burlington, and she had two great questions. She said, can I get a mortgage? I said, that's a great question. My understanding of the answer to that question is that it's certainly going to affect your credit score, but there's no explicit restriction on your ability to get a mortgage because of a conviction background. But the credit score thing is a big deal. Actually, maybe that's the better answer to the earlier question about non-punitive things that can sure feel that way, is if you do something that winds up hurting your credit score, that can be a really severe kind of punitive thing, but it's not a punishment. She also asked about volunteering for stuff with her kids' school. And that's another thing that's really decentralized all the way down, and where, an expungement or even a sealed or even a pardon might not matter, because public safety can still see even a lot of expunged convictions, which is another thing that we could talk about. If people are curious about that, I can say a little more about that. But yeah, what else?
So Nate had a really great comment that I want to point out about DCF, and having a DCF substantiation has an effect on things like jobs and housing. So
Yeah.
I don't know if you wanted to talk about that a little bit, Alec.
Yeah, that's been a really hard thing for me. This stuff feels so important to me and so intrinsically interesting, and I'm so undisciplined that I tend to follow these things, and I have the luxury in my job of being able to do that. And I've kind of I encountered this question when, and actually, if I can try again, and my ability to fail to use technology here is pretty much boundless, but let me see if I can do this again. Okay, here's the Vermont LNA document. Scrolling up a little bit, I think I might not have this right, but there's earlier, yeah, here we go. So child support. This is a really, really difficult problem. I was consoled a few years ago to learn there's an actual academic concept of the wicked problem, which is basically a problem that involves other problems and where solving one exacerbates the other. But getting people to pay their child support is really important. Preventing somebody from getting a job because they have outstanding child support creates other problems, arguably. So this is an area where I learned about this when I was studying licensure in a bunch of different states, and followed it a little bit, but all I can do is characterize this at the most general level, which is that in a lot of states, if you're trying to get a license, an occupational license, and again, I hope people understand, like, it's not just doctors and lawyers. Licensure, by some estimates, is now required some kind of government credential for a fifth or maybe even a quarter of all jobs, including the health occupations that are by far the fastest growing, the home care aides, right, the LNAs, the CNAs. Those jobs require a government credential. In a lot of states, unpaid child support and other kinds of civil restrictions, other kinds of burdens, you have to indicate that you're in good standing. And this is just this extraordinary place where, like, the civil authorities and the criminal justice authorities are really kind of interacting. Talk about a burden. Like, wow, I'm filling this out and I'm invited to contact the tax department. Like, thanks for telling me their phone number, but no thank you. Yeah, so I don't know if that's an answer, but yes, in many states, those kinds of civil consequences, unpaid child support, can absolutely prevent a person from proceeding through licensure. Yeah, what else?
Right.
I'm gonna turn this off. Yeah.
Another fantastic question. They are coming in. And again, if you want to ask questions, please raise your hand or put it in the chat box. So Alec, as you know, we've been talking about restorative justice for the past 5 months. That's been our focus. And Barty and Drew ask, what is the interplay with restorative justice when we're trying to get to the roots of things that cause criminal behavior, but they're so punitive?
Yeah, boy. This is really unsatisfying, or at least maybe it's just a technical kind of answer. And I want to repeat something that I said before, because I think it's really important to understand this. A lot of good things, a lot of good changes have been happening in the last 15 years. And one of them is laws like ban the box laws. Another is the increase, including here in Vermont, of the availability of things like expungement. Expungement, basically a Latinate word for erasure. Sealing laws. It's not erased, but it's closed to most people from most sources. Pardons. Real pardons are vanishingly rare. But there are certain kinds of lower level pardons in some states now. A lot of government authorities have listened to advocates, often people with backgrounds themselves, who've said, look, it's hurting public safety to prevent people from having a job, a good place to live, being able to be reunited with their family, and providing paths to that, like expungement and sealing, that might be easier than a full pardon for the courts to do, we should do that. That's where the certificate in New York comes from too. There's other states that have certificates like that too. Leaves the conviction in place. A restorative practice, and I know that from Professor Sand, you had a really good explanation of this, and we're a real leader in this area. We should be proud and grateful for that for a lot of reasons. A restorative sequence that might lead to me having my conviction set aside in some way. Maybe I get to go back to court and replead. Maybe it gets expunged. Maybe it gets sealed. These terms mean different things in different states. It's a good thing. It's not always clear what it means. I was just reading about Ohio. Let me just give you one example. A critical question that's at the intersection of expungement. Again, means different things in different states, but it tends to mean the conviction is treated as if it didn't happen. It's erased. It's not forgiven, it's erased. Sealing, it's still there, but most people should not be able to see it. If you're an employer or a would-be landlord and you run a background check on me and my conviction is sealed, you don't see it. Public safety can almost always still see it. However, in Ohio, but here's the question. When the employer asks me, do I have to say yes? They say, at the legal time, at the legal step in the sequence, have you ever been convicted of a crime? If the answer is yes, but it was expunged, what is my ethical obligation there and what's my legal obligation there? State laws are really unclear on this. And probation officers and others working in reentry I've talked to are really divided on how to handle this. One school of thought is you want to take control, and I think that Jeff, I won't speak for Jeff, but I think I've heard this in our conversations. If you can take control of that conversation and you can reframe your background and talk about the lessons you've learned and the distance that you've come, then that's what you should be doing anyway, whether you've got an expungement or not. Others say, no way. A minute that employer spends thinking about you having a drug conviction, that's a bad minute for you. And under the law of the state, you don't have to tell them, so don't. I was going to explain the vagaries and confusions of the Ohio law, but I would fail anyway. But it's this truly Kafkaesque. I've never really understood what that meant until I read this Ohio thing this week about if the employer thinks that the nature of my conviction would threaten public safety, then I have to tell them. Now, how I'm supposed to know what my employer's judgment is about whether this position, and again, that was a pretty close paraphrase of the rule. So a lot of these rules about, I know this is a convoluted answer, but sometimes a good restorative justice practice might lead to a conviction being set aside or expunged or sealed or otherwise dismissed or diminished. And it doesn't always mean that I don't have to disclose it. And it doesn't always mean that a licensing authority might say, oh yeah, this thing got turned up. And again, it's really perfectly valuable to come back to this at 12:59. I don't know what's sloshing around in those private databases about me. I just don't know. It might accurately say that it was sealed and dismissed. The employer might know what that means, but it might not. It might just say that I was charged. That private vendor might not have cleaned up their records. So it's really this ambiguity and the jeopardy, the precarious situation that people are in because of their backgrounds. That's something that the law really needs to do more about, to force those private background check companies to clean up those records. Do we have time for more?
We do. And actually, I have a question that's
Good.
something I do like to ask of our speakers. So we're individuals, we're all really interested in restorative justice. That's why we are here. But sometimes we feel like we're just one person. How can we as one individual feel that we have voice and agency to assist those in marginalized groups, such as people who were previously incarcerated, when it comes to something such as collateral consequences?
Yeah, honestly, some of it, and again, I'm here to talk about the formal rules. But again, it's really important that individuals, people, landlords, employers know that people with backgrounds can be really good neighbors and really good friends and really good workers. And having that kind of private change continue to happen is a really important part of this. If you were at the hearings a couple of years ago when Vermont enacted ban the box, you know, Richard Gagne was there. They listened to him. They listened to others with backgrounds who were at those hearings, who talked about their own experiences and who had hired people really successfully. Like, those kinds of stories really matter to legislators who are considering making these kinds of changes. So that kind of private level change can really matter. Again, it's hard for me to kind of imagine exactly what this might look like, but the kind of variation and discretion in these things, it actually makes an opportunity for people to kind of lobby or even just to educate a local housing authority or a county clerk. I mean, again, here in Vermont, I've talked to county clerks about this every chance I get. They send absentee ballots to people in Vermont prisons. But, just having a friendly conversation with them about, like, hey, I hear you do this, or do you do this, or that's great. Like, just making sure that local public officials know what the rules are, and letting them know that you value that and that they should keep doing that. And in any way that comes up, that you don't put a stigma on this, and that you're pretty comfortable talking about it, and that you've had good experiences, and that you just wanted to ask them about this. I hope that those kind of conversations can really help as well. So I don't know if that feels like not much, but yeah.
Very helpful. Thank you so much, Alec. It looks like we are out of questions and it's a little after 1. So really like to thank you for coming and participating. It's been wonderful. And thank you for giving us all of this information on collateral consequences. And I am putting into the chat box our link if anyone's interested in our Sister Helen Prejean event, again, coming up next month. So this is the conclusion of our Dismas speaker series, and we are hoping to continue this again in the fall. Keep an eye out for that. And again, we'd like to thank Alec for being here. This has been a wonderful last event for us. So thank you very much, everyone. Have a great rest of your day.
Thank you all so much. Write to me if you want.
And Alec, if you have any resources that you'd like to share, you can please send those along and we can send them out to everyone that attended today.
Yeah, I'll inflict things on people as they ask, but I'm happy to do that. Thank you all for your work and for spending your time this way, and for volunteering at Dismas and all the ways that you do. Thank you.
Great.
And thank you especially Jeff and Jennifer and our founder, Rita. Thanks, everybody.
Waving into a black screen.